did say he aimed, he pulled the trigger. I don't have a transcript of that, but it happened in a split second, and then...
Well, that may be... Actually, he may have at one point in time on cross said, yes, I aimed and pulled the trigger. Now, that was not his position or narrative for an hour and a half, but I think, Mr. Huebner, you can correct me if I'm wrong, at one point he actually said, yes, I aimed and pulled the trigger.
I don't remember that. If the defense and the court remembers that testimony, then sure. Then I will defer to the court. I don't remember him ever describing aiming at the victim, but maybe I'm wrong.
I thought, as I recall, you asked something like you...
Oh, that was when we were talking about his weapons training, because I was shocked to find out that he apparently had learned to shoot at what he aimed for. So...
It was also actually on redirect as well.
I'm sorry, can I take you down if I can't hear you?
I indicated that it was also asked on redirect as well, where Mr. Edgecomb indicates that, you know, when he was asked the question, what factors led him to determine that there was an imminent threat at the time that he picked up the gun, aimed it at Mr. Cleereman, and pulled the trigger. And then he went on to describe those factors that was responsive to that observation. So he also indicated that intentional act at that very moment as well.
And Judge, I just have one thing to point out to the court regarding this issue of negligent and self-defense. There is a case on point, I believe. The case is State v. Carroll D. Watkins.
Spell that, please.
Sure, Judge. State of Wisconsin versus Carroll D. Watkins, Carroll D. Watkins, and the citation. This is a Court of Appeals case filed July 11, 2002. And basically it appears, I'd like to just maybe process this, but I can send the authority to the court. It appears from my just initial review of this that the Court of Appeals found that those two concepts were not mutually exclusive from what I have here. I'll forward it to counsel, but maybe we can take up that issue finally tomorrow, just so we have enough time.
All right, we can table it for now. I expect both sides to discuss the matter. The other instructions all appear to be in order. Again, they're pretty much pro forma exhibits, police reports, weight of evidence, credibility of witnesses, impeachment of a witness. I did not see the instruction on the defendant testifying. Oh, you're right, I see it.
I put it within the credibility in 300, assuming the defense wants it. I also have 327 and 325, which are both impeachment of witness and impeachment of defendant with the prior conviction, because I think Jose Perez had convictions. I would note...
Hang on. Yes, in instruction 300, credibility of witnesses, it does have the paragraph, the defendant has testified in this case, etc. I presume the defense is requesting that. Is that correct?
Yes, regarding the defendant testifying, yes.
And fine. Then there's 325, impeachment of a witness with a prior conviction, because I think the state's correct, at least one other witness, I think one of the people working at the bar said he had a prior conviction or convictions. And then 327, impeachment of the defendant with a prior conviction. I believe those are appropriate as well. It's my inclination right now, it's not a final decision, my inclination is to give the instructions as drafted, including the self-defense instruction, including first and second degree intentional homicide and first and second degree reckless homicide. It's not a final ruling, but that's my inclination. We're going to break for there. It's almost 4:30. Back, please, at 8:30 so we can tie up any loose ends and I can instruct the jury at 9. We're in recess. Thank you.